Hello, my name's Olurotimi Osha. I like to talk about American presidents, and I'm continuing with my discussion on the 25th Amendment. I'm going to give a quick summary of the 25th Amendment, which has four sections. In an earlier video, I may have misspoken a couple of times, and so I'm going to correct that. I do apologize. Um, so the 25th Amendment, of course, ratified in 1967. It has four sections. The first section that says that if the uh, president, dies, you know, dies in office, or he resigns, or he's removed through impeachment proceedings, then the vice president shall become president. That's the First Amendment, and that's consistent with practice, right? The first a vice president to succeed a president who died in office was John Tyler. John Tyler succeeded President William Henry Harrison when he died after just 1 month in office. So that's consistent with practice. Now, the second section of the so that was the first amendment. Sorry, that was the first section of the 25th Amendment. Again, 25th Amendment has four sections. The first section, that's just the where the president is removed from office through death, or he resigns. President Nixon resigned, for instance, and or he's removed from office through impeachment proceedings. That has never happened. But in any event, the vice president shall become president. That's section one. And section two of the 25th Amendment, um, that basically um, it's in the event that there's a vacancy, there's a vacancy the in the vice presidency, right? Then the president shall appoint um, a new vice president, and who will be approved by Congress by a majority vote of Congress, right? So that's the uh, second section of the 25th Amendment. Um, Again, I'm just going to remind us that in our history since the presidency of George Washington up until 1967, uh, for an aggregate of 37 years, we've had uh, no vice president for an aggregate of 37 years. And the first time it happened was with John Tyler. John Tyler did not have a vice president because there was no 25th Amendment. There was no provision for the appointment of a new vice president. Um, Millard Fillmore did not have a vice president. Franklin Pierce, Franklin Pierce did not have a vice president. And significantly for some of his presidency, that's President James Madison did not have a vice president because um, uh, two of his vice presidents died in office. George Clinton, he was a very old man. He'd been governor of New York. He died in office. And Elbridge Gerry, Elbridge Gerry, sorry, and it's from his name that the word gerrymandering comes from. Anyway, Gerry, he used to be governor of Massachusetts. Excuse me. Um, he died in office as well. So James Madison had two presidents who died in office. So after Elbridge Gerry died, he didn't have a vice president. I guess everybody saw it as a bad omen or something. But yeah. So the second section, it makes provision for uh, the president to appoint a um, a new vice president who, with a majority vote of Congress, um, he's approved. Right now, the third section, excuse me, I have a slight cold. Um, the third section deals with where so it's sort of a voluntary relinquishing of power, transfer of power from from the president to the vice president to serve as acting president when the president is going through some kind of medical procedure, and this has been used often. It was used by President Reagan in 1985 when he had surgery for colon cancer, and so he transferred power to um, George H.W. Bush in 1985 for roughly about 8 hours. It was also used by George W. Bush, that's who transferred power to Dick Cheney, his vice president, for just not too long, maybe less than 3 hours or so, when he was going through a colonoscopy. And President Biden as well, uh, transferred power to Vice President Kamala Harris, who was acting president while Joe Biden was going through a colonoscopy as well. So that's the third section, right? So basically, the president is voluntarily transferring power to his vice president. Maybe when they're undergoing some kind of medical procedure, right, and they can't function, just in case something happens. So very temporary, voluntary. The fourth one is in the fourth section of the 25th Amendment. That's what everybody's talking about in the wake of President Trump's um, indiscreet, his reckless comments threatening genocide of the Iranian civilization. It was an indication he intended to use nuclear weapons, and so, of course, that mortified Americans and the rest of the world. And so, even conservative pundits, talking heads like Candace Owens and uh, Marjorie, former Congresswoman Marjorie Taylor Greene, were calling on the 25th Amendment being invoked, right? So, but invoking the 25th Amendment isn't as easy as that. So basically, it's instigated by the vice president, right? So the vice president, with a majority vote of principal officers of the cabinet. So that's like the secretaries of the respective departments. There has to be a majority vote, or alternatively, a body that's appointed or created or by Congress, right, for this purpose, right. So there's got to be a majority vote. Excuse me. There's got to be a majority vote that the president has lost capacity, right? Does not have the capacity to fulfill the duties of his office, right? That he's either and unwilling or unable, right, to fulfill the duties of his office. So typically, the president is supposed to do it voluntarily, but if he's unwilling to do it voluntarily or unwilling to voluntarily transfer power to the uh, vice president during this period of incapacity, then the vice president and then majority vote of the principal office, that's cabinet secretaries, right? The heads, cabinet secretaries, basically. Or, as I said, an alternative body created by Congress, by law, through law, right? Then they have to have a majority of votes uh, to to say the president has lost capacity, right, to execute his powers and duties of the office of president. So then they have to now send a written declaration, which is an affidavit, to Congress. That's to the president pro tempore of Senate and the Speaker of the House, right? And that's all they have to do. That's all they have to do. And then the vice president immediately assumes the role of acting president. Acting president. Now, Section 4 at no time indicates that it's a fail-safe mechanism to permanently install the vice president as president, right? So they continue to use the term acting president throughout, right? Throughout this period of incapacity, acting president, right? Um, Not uh, permanently president like in section one, right? Section one, where the vice president permanently becomes the president. So, and what's crucial again is that the president is able uh, to actually send his own written declaration to Congress, right? Send his own affidavit to Congress. That's both to the president uh, pro tempore of Senate and the Speaker of the House that his capacity to serve as president has been restored, right? And then he simply resumes duties unless the vice president with the majority of cabinet counter and say that and insist that no, that the president um, still lacks capacity, that his inability to serve has not been restored, that he lacks capacity, and it has to be written as well. Then, there's a process where in that case, if Congress is not already sitting, and within 48 hours, Congress should be assembled, and they should be assembled, and so there's a time frame for the vice president to respond, right? I think within 4 days or so. But importantly, Congress must now take a vote, right? They now have to have a vote by uh, two-thirds majority. Both houses of Congress by two-thirds majority have to decide on who is president, whether it's the vice president or the president. And if they somehow decide that it's the vice president, that the capacity of the president has not been restored, then they will, then the vice president will continue to serve as an acting president, right? So that's where the fourth section of the 25th Amendment ends. And what makes it difficult is that it's never been invoked, right? It's never been invoked, so that's what's problematic about it. And also, it's never been taken to the Supreme Court, right? It can be taken again. The Supreme Court doesn't have an advisory role, right? There's got to be cases and controversies. Maybe if J.D. Vance tries it out and then eventually goes to court, and the Supreme Court can get to opine on it, right? They can decide, they can interpret it. What does it really mean, right? So that's one of the problematic things about the fourth section of the 25th Amendment, which, it doesn't also easily define capacity. And I'm going to do subsequent videos regarding incapacity, because incapacity is a legal term. Everybody's been using ad hominems, and that's all it is when they're saying, well, Donald Trump is crazy, or he's lost his marbles, or, things like that. His mental capacity is diminished. First of all, the fact that a president is even insane, or he's lost his marbles, his mental capacity is diminished, it doesn't mean, well, historically, remember there's precedent. We've had presidents who actually, back in the day, they would be qualified as insane, right? But, insanity is no longer is now deemed a pejorative, right? In the medical field, in psychiatry, in the medical field, they don't use insane anymore. They use mental illness, severe mental illness, mental disorder, and these are supposed to be treatable, right? So things have changed. Are supposed to be treatable. And besides, as I was saying, there have been presidents who've had diminished capacity. Most recently, we all saw why what happened with President Joe Biden and President Trump during the debates. Was it in 2024? Um, and right live on TV, we saw he had diminished capacity, diminished mental acuity, and there was this uproar. Everybody was clutching, the whole nation, clutching the pearls. and eventually President Joe Biden withdrew from the campaign. Right, he wasn't going to run for a second term because the America witnessed his diminished capacity live on television, right? And so we know there's also a political aspect. So even if the so we've had presidents who've had diminished capacity, but he wasn't. They didn't invoke the 25th Amendment. So you saw the cabinet protected him. He has his aides, they'll protect him, right? But we saw live on television that President Joe Biden had he evidenced diminished capacity, right? His mental acuity had significantly diminished. There's an argument that he was impaired. So by the way, defining incapacity is very difficult, right? Uh, Although President Ronald Reagan was not formally diagnosed with Alzheimer's until 1994, several years, roughly 4 or 5 years after his presidency, right, ended. But his son insists that he demonstrated signs as early as 1984. That his son claims that he was showing signs of Alzheimer's already. So again, many of these doctors, psychiatry, um, they're subjective, right? One doctor might say one thing, another doctor will say something else, especially when it comes to mental health, right? Mental health, mental illness. One subject, it's a very subjective issue, right? Mental illness is very highly subjective. One person might say something, another person might say something else. Besides, I think I've read the biographies of Ronald Reagan. I think most recently I read one written by Max Booth. I've read a biography in the biography of Colin Powell. If I recall, his comments about Ronald Reagan, because Colin Powell, of course, served in President as an advisor to President Reagan. But one of the challenges is it's difficult. You don't know what was dementia or indications of Alzheimer's with President Reagan, especially since he was very pretty old, as president. Up until to his time, prior to Joe Biden, President Reagan was the oldest person as president, right? So he was pretty old, and you don't know what was. And then the other thing, the challenge is Reagan wasn't known to be the sharpest tool in the box. So you don't know what it is, side things, what indications are. Is it because, he's if it's just a normal, not so intelligent person that's demonstrating signs, or if it's his, you don't know what's going on. But his son does indicate that he was already showing signs of Alzheimer's or dementia, in the 80s while he was still president. But even apart from President Reagan, and again, President Joe Biden, we've had presidents, and none of these, by the way, so that's my point, none of these had the 25th Amendment invoked against them, right, for removal, for lack of capacity. Um, and even prior to that, we've had presidents who had manic depression. Manic depression used to be synonymous with being insane, right? It's bipolar today. Again, it's a pejorative. Insanity is not used anymore in medical field. Insanity is still used in the legal sense as a defense. For criminal defendants, right? They can take a temporary insanity plea or an insanity plea. So it depends on the state. So insanity is still used as a legal defense, right? That's because to be, our criminal justice system has a requirement of mens rea, right? Guilty mind that you have to have the mental states to form a crime, right? You can't get a conviction without those two, without actus reus. That's maybe the physical act, right? The actual action, and then there's the mental capacity, mental mens rea, right? Mens rea is the guilty mind, right? The capacity to form a crime in your mind. So you find many people want to get off being convicted of a heinous crime of murder or something like that by claiming diminished capacity, that lack of mens rea, that that they were insane. So in that case, a judge sends them to a psychiatric hospital for treatment instead of sending them to prison. So that's where uh, you know society can look into the mental capacity of someone, mental health of someone when they're facing a criminal case. Other than that, your mental health, that's within your zone of privacy, right? So zone of privacy with healthcare, advanced healthcare today, zone of privacy. If somebody even has a severe mental illness, they can just see their psychiatrist or whatever and get treatment, and it's a private affair, and they can normally manage mental illness, even severe mental illness, right? So that's one of the things that makes it challenging. But back in presidential annals, we've had people who had very severe mental illness, but they functioned very well. Our favorite president, the best president we've ever had, Abraham Lincoln, suffered from manic depression. Manic depression, it's now called bipolar disorder, a severe form. He suffered from bipolar disorder. His wife, in fact, I think after he died, his wife was committed by her family to an insane asylum, right? So it's something our presidents have had. Uh, John Adams, our very second president, I've read his diaries. In his diaries, he's writing clear symptoms of manic depression, bipolar disorder, very severe form, right? Today, of course, they didn't have a diagnosis for it back then in his times, but today, psychohistorians, as they call them, or psychiatrists who study, the biographies and lives of our previous presidents, they are of, the consensus that John Adams suffered from bipolar disorder. So did his son, John Quincy Adams, our most brilliant president. And that's another challenge again. We've had many instances that, extremely intelligent people, because they're different from the rest of the population. We don't know what is eccentric, what we deem to be eccentric. They might just be extremely intelligent, and we might mistake that. So the notion of perception, right? If the public just has a wrong perception that somebody is acting insane, right? So it's very difficult. There isn't a bright line mechanism to this method for determining the incapacity of someone, especially a public official like a president, especially since we've had presidents who suffered very severe mental illness. There's Teddy Roosevelt. Teddy Roosevelt suffered very severe uh, mental illness, bipolar disorder. Everybody's of a consensus that he did have very severe bipolar disorder. That's Teddy Roosevelt. His son his son actually committed suicide from because of mental illness. So it's a challenge, saying, well, because again, with better healthcare, it's manageable. So you just can't say, well, because President Trump is making bad judgments, that so they can invoke the 25th Amendment to remove him from office. So it's very difficult to determine um, how to determine incapacity due to severe mental illness. It's very difficult to determine that. Again, insanity is used uh, in courts, but as a matter of propriety and with respect to our medical rights, zone of privacy, no one uses insanity anymore, because again, many people who suffer from what would have been very severe, what would have been deemed insanity in the past, they manage it, right? They're able to get treatment and manage their lives. Of course, there's still people who are committed because they're not able to, they have this very severe mental illness, but they have to have a diagnosis first, and it prevents them from being able to function, or, from living a normal life, or uh, conducting their regular activities, they're not able to take care of themselves. Well, if the president ever reached that stage, again, he's wealthy enough to afford care to take care of himself. But if that ever were to happen, it's something that has to be initiated by the vice president, uh, and then his the cabinet. They'd have to vote on it. But tough luck doing that because yes, yeah, I mean he's surrounded by sycophants, and again, unless the president has actually stripped himself naked, right? And he's in the case of the emperor has no clothes. He's severely delusional. He just gets on TV. He strips himself naked and is walking around. Okay, then that's when, it's very likely that it's very easy to get the vice president and his cabinet to invoke the 25th, or unless he's outright there trying to kill all his cabinet members doing something, then they can do that. But he hasn't reached that stage. He's just demonstrated bad judgment, the same bad judgment that a lot of Americans have considered that he's inconsistent. That's consistent with Donald Trump. He threatens to use, nuclear weapons, right, on Iran. Um, but this is exactly what the electorate knew before, right? His opponents had raised this before. So it's consistent with his behavior, right? It's consistent. It's not like he's changed dramatically or drastically. It's consistent with whom the electorate or the American people know of Donald Trump, because this is what his opponents have said, that you can't trust him with nuclear weapons. He'd want to blow up people and things like that. So it's consistent with Donald Trump. All right, so uh, that's not lacking. That's not the legal term for lacking capacity. And not that the 25th Amendment even says that, okay, there has to be a legal uh, determination, right? A legal or even a medical determination of him lacking capacity. So it's difficult. Maybe JD Vance will try it, and it will go to the courts, and we'll see what the Supreme Court says about that. And so maybe that's kind of what we need to be able to understand the fourth section of the 25th Amendment better. But in any event, I'm going to use this as an opportunity to discuss the history of the courts declaring people um, insane, right? So there was a woman named in the 19th century, remarkable woman, Elizabeth um, Packard. I'm going to discuss her. Her husband, she was actually a very intelligent woman, but she was an oddball, a bit of an oddball. She seemed an oddball. I mean, she was an outlier for her times. She didn't follow conventions, and her husband, who was a minister, decided to declare her insane, and she was locked up in an asylum for a long time. But eventually, it was determined that she wasn't insane after all, and she was an activist. She became an activist regarding not just women's rights, but also, treatment of people perceived to be insane, right? And so society has changed a lot. And I'm going to do something regarding cases, right? There have been cases, many important cases. I think the other day I discussed O'Connor versus Donaldson, a 1975 case, and I'll discuss some other cases as well regarding um, diminished capacity and the courts. So uh, it's not straightforward. It's not a bright line uh, um, issue determining the incapacity with respect to the mental state of a president. It's not straightforward to do that, to make that determination. My name is Oluru Timiosha, and I will keep you posted. Thank you.